Start. The 1872 Act extends such permission in terms of Section 76 read with Section 79 and 80 of the 1872 Act, and as in the case of Official Gazette under Section 81 of the same Act. Even other legislations concerning public documents attach equal importance to the authenticity of such documents, including while making changes in their certificates, to which we have alluded to in this judgment. Understood thus, there is no reason for the CBSE board to not take notice of the public documents relied upon by the candidate and to record change on that basis in the certificate issued by it, for being consistent with the relied upon public documents. It matters not if the information furnished in the public documents is not entirely consistent with the school records of the incumbent. The CBSE, while accepting those documents as foundational documents for effecting changes consistent therewith, may insist for additional conditions, and at the same time, while retaining the original entry, make note in the form of caption/annotation in the fresh certificate to be issued by it, while calling upon the incumbent to surrender the original certificate issued by it to avoid any misuse thereof at a later point of time. It would be permissible for the CBSE to insist for a sworn affidavit to be given by the incumbent making necessary declaration, and also to indemnify the CBSE. The fresh certificate to be issued by the CBSE may also contain disclaimer of the board clearly mentioning that change has been effected at the behest of the incumbent in light of the public documents relied upon by him. In addition, the incumbent can be called upon to notify about the change in the official gazette, and by giving public notice as precondition for recording the change by way of abundant precaution. Para. The question is whether there was an enforceable legal right in favor of students to seek such a direction, and whether bylaws have the force of law and directions can be issued by the court only in conformity thereof. The impugned judgments categorically note that the request for changes could not be permitted as per the bylaws. Thus, there was no demonstration or inquiry to determine the existence of any legal right in favor of students, even if we assume that courts issued directions purely on the basis of fundamental rights. There is no discussion or inquiry in this regard. More so, there is no attempt to examine the bias of the bylaws in light of the breach of fundamental rights, as discussed in the initial part of this judgment. Absent any such adverse determination on the validity of the applicable rules, the fundamental principle of rule of law demands that such rules be given their intended effect. Even if a constitutional court feels that the case at hand is deserving of an extraordinary remedy, it may do so using its wide powers under Article 226, but only upon specific appraisal of the facts of the case and after duly demonstrating the extraordinary character of the case. Despite holding that the prayers are impermissible under the bylaws, the courts in the present set of cases went on to issue directions to the board without having any regard to the factual circumstances of the case or to the nature of changes sought by the students, by mechanically relying upon the dictum in Shubin Muhammad (Supra). We must note that Shubin Muhammad is not in challenge before us, but must be now understood in terms of opinion recorded in this judgment. Our concern is with the manner in which mechanical reliance has been placed upon the earlier decision for deciding cases which involved an altogether different set of changes. Stop.